Welcome to Competition Law course, and dear learner and viewer, we have been discussing the competition laws and policy and enforcement in China, and we have taken note in the previous lecture that how the Chinese law and the enforcement and administrative agencies have come in a very formidable manner to regulate the entire competition laws and policy in China. Today, dear learner and viewer, I am going to discuss a very important issue of the Chinese competition laws and policy. Happens to be that whatever is the corpus of the competition law in China and whatever happens to be the administrative paraphernalia for the enforcement of the competition law in China, what is the sign, what is the trend, and what is the upbeat and what is the mood of the Chinese legislature and the government in relation to the competition laws and policy, meaning thereby that what are the recent changes which are likely to be undertaken and is undertaking within the Chinese jurisdiction on the count of the competition law, how they are undergoing to a kind of a sea change and legislative upgrades and redesigning of their competition law to serve the better purpose in matters of extraterritorial application of the competition law and as well as the transnational application of the competition law. So, we will straightway try to understand as to what is the nature, range and the gamut of the reform which the Chinese government and the Chinese economy is undertaking in the name of the competition law and policy. With this, dear learner, I will just recall that what we have learned so far during the last two lectures on the China, what we learned actually that we have taken note of the law relating to provisional rule on the development and protection of socialist competition 1980. We have taken note of law of People's Republic of China for countering unfair competition 1993, and we have taken note of anti-monopoly law of the People's Republics of China 2008, and we have tried to see that how the Chinese law on countering unfair competition 1993 have addressed the issue of the prohibition of anti-competition behavior as well as the regulation of public utility operators and government, how the law relating to countering unfair competition 1993 tries to address the question of predatory prices. It tries to prohibit collusion in bidding and try to oppose any kind of an administrative monopoly. And then we have taken an appraisal of the anti-monopoly law of People's Republics of China 2008 in relation to the merger control, in relation to prohibition of anti-competitive monopoly agreement, in relation to prohibition of abuse of dominance, and we try to see that how that the anti-monopoly law of the People's Republics of China 2008 tries to create a kind of a mandatory situation wherein all the firms and businesses have to seek clearances, approval and the consent from the government. However, what happens to be the range and a scope of the anti-monopoly law of People's Republic of China 2008 in the matters of competition concern or in matters of affording some kind of an exceptions to the IT industry, to the product and quality efficiency and enhancement of the legitimate interest and social public interest in matters of energy conservation and the environment protection. Then, dear learner, you can also vividly recall that how the competition policy in Chinese institutional framework happens to be very flexible, very resilient, very exuberant in order to steal the march of the Chinese market, domestic market and as well as the global market, and how meticulously it tries to engage on that question and how it tries to develop its entire paraphernalia of the enforcement of the competition law, the administration of the competition law, and how best the Chinese competition law tries to create an anti-monopoly committee to look into all kinds of matter relating to the legislative reform, policy formulation, and as well as the publication of guidelines, protocol, standard operating procedures. And on the other side of the execution, the enforcement, how the anti-monopoly enforcement agencies happens to be a very vibrant organizations responsible for the enforcement of anti-monopoly law of People's Republic of China 2008. And then we have noticed that the subsidiaries of the anti-monopoly enforcement agencies, be that the National Development Reform Commissions and its responsibility in matters of price related offences, and its sobering achievement in matters of LCD manufacturer, in matters of automotive part, in matters of consumer oriented sectors of automotive, electronics, eye care, milk powder, pharmaceutical, premium liquor and insurance sector have made a salutary impact in realization of in curbing the hardcore cartel agreement and in curbing the price fixing agreement and in realization of exorbitant fines to the coffers of the Chinese economy and the Chinese finances. We have also seen the State Administration for Industry's role and responsibility in giving effect to the three fundamental objectives of the anti-monopoly law of People's Republics of China 2008 in matters of enforcement of monopoly agreement, in matters of abuse of dominance, in matters of abuse of administrative control. And lastly, we have seen the role of Ministry of Commerce, which is made in charge of to see and supervise entire merger control in the Chinese economy, and a comparative analysis of these enforcement agencies and executory agencies in matters in the framework of the anti-monopoly law of People's Republic of China 2008 have given a very rounded picture of the competition laws, policy, enforcement, execution of extraterritorial application of or the transnational application of the competition law in a right manner, in a right direction. Today what we will try to add on to the last lecture on the Chinese competition laws and policy is the fact that how the Chinese economy is giving a very lot thinking on the issue that the anti-monopoly law of People's Republics of China 2008, which has completed almost more than 15 years of its legislative history, needs a change. And in that respect, what are the churning process which is in the Chinese economy and the legislative corridors that we are going to discuss, and what we see that it is going to amend the anti-monopoly law, especially the State Administration for Market Regulation, and it tries to make a state administration for market regulation to be very effective from 2020, and this has an approval of the Standing Committee of the National People's Congress in 2021, and then the government is going to release the draft amendment for its public comment and soliciting some kind of the advices. So the range of the change and the reform which is going to be considered under the 2000 anti-monopoly law People's Republics of China 2008 happens to the fact that it tries to see are there any kind of a changes to merger review process and penalties are required, or the State Administration for Market Regulation which is responsible for imposing the fines, and what are the issues involved in the realization of the fine by the State Administration for Market Regulation in matters of the general industry, in matters of on internet platforms or the information and communication technology. That amendment is also going to see the larger impact of the decisions of the conditional approval of the two cases which we will be referring in times to come, and the two cases happens to be the Global Wafers Company Limited's acquisition and as well as the acquisition of Xilinx and Avinsec JV with EAL. So with these, what lessons we have learned out of the conditional approval which was granted to Global Wafer Limited and Xilinx and Avinsec JV with the extraterritorial application of the competition law. The reform is also going to see that as to how the non-merger enforcement actions are to be initiated in public utilities, in healthcare, in construction, in platform companies, and then it is also going to see that how the resale price maintenance practices as it has been exhibited by the Gistlik Pharma AG case need to be addressed. Thus, we see the entire canopy of the reform and the entire slew of reform which is just revolving around these issues are going to take place. At the same time, what we see that there are going to be some amendment in the anti-monopoly law, and that amendment pertains to primarily on the large issues, but the key and the substantive issues which are scheduled and slated for the change in 2022 in the China happens to be the review of non-threshold transaction, meaning thereby whether the state administration for market regulation happens to see and to what extent the state administration for market regulation tries to enable the review of non-threshold transaction by requiring notification of the transaction, or it can eliminate or restrict the competition. The anti-monopoly law reform or amendment 2022 is also going to address the issue of introduction of the stop the clock system, and that system is very important because there happens to be a large number of public lawsuits which allows prosecutor to bring civil lawsuit against the undertaking acting against the social and public interest. So that have to be seen under the very precincts and the framework of the anti-monopoly law. The anti-monopoly law amendment is also going to hit some of the issues of the safe harbor for vertical monopoly agreement by introducing some kind of the agreement and making certain condition imposed on them, and then this law is also trying to address the issue of prohibiting organizing or undertaking a monopoly agreement which is known as the cartel facilitator issues. That is also taken into care. And lastly, the anti-monopoly law reforms is going to address the issue of the increase and enhanced penalties and its realization. Thus, we see that the anti-monopoly law amendment 2022, which is going to be introduced some substantial changes to the Chinese merger review process, and it is going to introduce many new penalties and liabilities on the individual, is to be seen and to be waited and to be watched as to what happens to be exactly the nature of reform or the amendment. Then the other aspect we see that there are 6 antitrust regulations and rules, and the Chinese government has also piloted in 2022 that 6 antitrust regulation and rules must be put in place. The first happens to be that a regulation on the filing the threshold concentration of the undertaking. Then they are also going to have some kind of a provision of the monopoly agreement. They are also discussing and debating as to how the provision of the abuse of dominance are to be thrashed out, and they are equally giving some attention to the provision on the prohibition of elimination and restriction of competition through intellectual property rights, and the 6-fold reform or the 6 antitrust rules and regulations which are going to be in place, which also contains something relating to the abuse of administrative power. That means, can there be any kind of a provision for prohibition of elimination of restriction of competition through abuse of administrative power, or we can think of and visualize any kind of a provision on concentration undertaking, and we can draft the state agency for marketing regulation, and then we can see that what proposals and what slew of reforms can be done into the implementing rules or 6 antitrust regulation rules which has been proposed in 2022. So we see that and lastly what we see that the China is also going to amend the anti-fair competition law of 1993, and they are of the view that whether this law happens to be a kind of a success in arresting the misappropriation of the trade secret or the trademark infringement or the commercial bribery or the false advertising vis-a-vis the anti-unfair competition law of 1993 will address 4 major issues, and the 4 major issues are: number 1, carrying out of the malicious transactions which obstruct and undermine another's undertakings normal operations, which is given under Article 14 of the Anti-Unfair Competition Law 1993. It is also going to look into the issue of using technological means or platform to access to the transaction of the goods and services, which has been mentioned under Article 17 of the Anti-Unfair Competition Law of 1993. It is also going to look at the improperly obtaining or using commercial data, which has been provided under Article 18 of the Anti-Unfair Competition Law 1993. And lastly, it is going to use algorithm or the artificial intelligence under the very basis of the Article 19 of the Anti-Unfair Competition Law 1993. So these 4-fold of reform are going to be addressed under this Anti-Unfair Competition Law, and they have proposed 6 antitrust regulations and rules. Vis-a-vis, they are going to amend the anti-monopoly law of 2008, and thus we see that the Chinese economy and the government happens to be in a mood of introducing and setting new range of reform on the competition law. And lastly, what we will be discussing, that there are 2 cases which happens to be of a great importance. The one happens to be the acquisition of Global Wafer, as we referred in the earlier case, because the major reform of the Chinese competition law is going in the backdrop of Global Wafer Companies Limited and the acquisition of Xilinx and Avinex JV. And then we see that the first case, which have some kind of a ripple effect in giving direction and force to the reform of the competition law in China, happens to be a case that the acquisition of the Global Wafer by the Siltronic, and there are large number of issues. The one happens to be the transaction potentially resulting into combined entity holding significant market power or potential negative impact on competition, and some kind of a concern in a number of competition and coordination. And then how in the backdrop of this case we can be able to have to ensure a fair, reasonable and non-discriminatory terms of Chinese customer, those requirements of divestiture and the entire divestiture and acquisition of the Global Wafer Zone melting wafer business within a short period of time, and the entire issue of the acquisition of the assets is one of the very important case which have a great impact in giving a flip to the reform. The other case, which happens to be the case of acquisition of Xilinx by AMD by imposing for some few remedies, and the remedies happens to be refraining from bundling or imposing unreasonable condition while supplying the CPUs, GPUs and FPGAs in China, and then continuing the supply of CPUs, GPUs and FPGAs on fair, reasonable and non-discriminatory term, and ensuring the interoperability of the parties of the CPUs, GPUs and FPGAs with those from the third party manufacturer, guaranteeing the flexibility, programmability and availability of Xilinx FPGAs and maintaining confidentiality of competitive sensitive information of the third party manufacturer. So, the case of acquisition of Xilinx by AMD and the case of acquisition of Global Wafer by Siltronic happens to be a tale of two cases which have been the backgrounder for recent process of churning of the competition law in China in relation to some kind of the changes to the anti-monopoly law of 2008, some kind of the changes in relation to anti-unfair competition law 1993 and some kind of a changes to propose 6 antitrust regulations and rules and try to refurbish and embellish the entire competition law and jurisprudence in China, and we are waiting and watching that how this slew of reforms of the competition laws and policy having a direct bearing and impact on the extraterritorial application of competition law and the promotion of transnational competition law. With this, dear learner and viewer, we understand that the discussion on the entire recent changes in the competition laws and policy with changes in the existing law and proposing the new range of the laws and the case law experimentation in China will further strengthen our understanding in conceptualizing the extraterritorial application of the competition law in BRICS country in general and China in particular and world at large in general. With this I conclude and I wish you a happy learning.